behalf of?
as Islam.
Okay.
So only for the day, Your Lordship.
Learned Counsel Mr.
M. Haq.
M. Hope, Vice, VIC Vice. Learned Counsel Mr. S. Islam has prayed for adjournment. Learned Additional PP Miss Endas has submitted the CDs not received. Okay, not received CD. CD not. Issue reminder, list the matter on 24. It was item number?
19.
Okay,
No interviews, Your Lordship.
Yeah.
I'm obliged.
24 June.
May it please the Lordship.
Hmm.
Lordship, this AB has been listed on 4/6/2025, Lordship,
Hmm.
as a leftover matter, Lordship. It didn't reach. So may I pray for listing it for tomorrow, Lordship?
Please hurry to rush to court number.
Court number 11.
Yes.
May please your lordship. May please your lordship. Lordship, item number 11, lordship, on behalf of respondent.
Hmm.
Lordship, I'm just praying for taking up the matter at 2, lordship, in the second half.
No, not at all.
Second-
There are 2-3 matters.
Lordship, then I'm praying for an adjournment. Lordship, I have some medical emergency.
Okay, Learned Counsel Mr.
G Das, lordship.
G Das, have you taken consent of the other
Lordship,
side?
I have not found, lordship, that's the only.
G Das has prayed for adjournment as he has a medical emergency, medical urgency.
Lords.
List the matter on 23rd.
May I please, Lordship, with the consent of other party, I'd like to mention item 12, Lordship.
12.
Yes, Lordship. This matter we kindly adjourn for today.
Item number?
12.
Learned Counsel Mr.
S. Sharma on behalf of AK Protesting.
S. Sarma.
Yes, Lordship.
On behalf of Learned Counsel Mr. A.K. Purkaster, with the consent of the other side, has prayed for adjournment. List the matter on
After weeks, Lordship.
after vacation.
Obliged, Lordship.
List the matter after summer vacation.
Obliged, Lordship.
May please, your lordship. Lordship, I beg to mention item number 20, my lord. My lord, possible for the day, my lord. Senior is out of station, my lord.
Learned
Next
Counsel
week.
Mr.
20 case they receive, my lord.
Why Ali?
We'll send it back. Why Ali has prayed for adjournment. CD is received, sent back to CD. Call for the up-to-date CD. List the matter on when do you want after vacation.
No, my lord. 20 June.
Then we'll retain the CD.
25th.
Send back the CD to Kahiria. CD
Hello.
is received. CD to be retained till 22nd June. 20 June. List the matter on 20 June.
I love bless.
Lordship, I
Hmm.
beg to mention item number 24. My senior is out of station, Lordship, for some urgent work. The matter, prayer for matter may fix on 17/6/2025, if possible.
Why have you taken consent from the other side?
No, Lordship.
No, okay.
I-
Learned Counsel Miss, yes.
And Devi,
And Devi, on behalf of Learned Counsel Mr.
R. Goswami.
R. Goswami has prayed for adjournment as Learned Counsel Mr. R. Goswami is out of station. List the matter on 17 Divya.
17/6.
20 June
17,
2020.
29, obliques.
Item number 1.
This my lordship.
One, my lord, where one report was called for report, my lord, not any short date, my lord, I will get it, my lord.
Report as called for is not received. Issue reminder, list the matter on short date at a detail. 19 June.
Obliged.
Item 2.
My Lord,
Yes,
this is a criminal revision, Lordship.
Uh,
What has happened in this case, Lordship? This is a petitioner before Lordship is a victim in a POCSO case
Hmm.
presently undergoing at Nagaon, Lordship. That out of the prosecution witnesses, 5 witnesses have so far been examined. Now, the background of the case is this, Lordship. The victim alleged
You call for, we'll call for
My
a
lord.
report, or have you received any report?
No, not this.
Report, call for a report relating to the vehicle seized in connection with this case, being vehicle number.
Okay, equal number lordship. AS04N255. AS04N.
A04N
and
2555, comma, a Maruti Suzuki, a Swift Desire.
Lordship.
List on last week of June,
My lord.
26 June,
Lordship, it is lying since 2023.
26 June. 16 days only. 16, not even 16 days, 14 days.
Obliged, Lordship.
ठीक sir.
Hmm?
My lord, last occasion, two occasion, the report was called for status of the matter, my lord. Actually,
You have this.
no, not.
Status
It is from the
report is-
Pan Bazar Government Police Station.
Tell it.
My lord, I will take this.
It is
I will-
from the Pan Bazar, my lord.
I will
It
take
is the
care.
second date actually.
19 June.
19.
Item 6.
Wait, please, your lordship. Lordship, my learned senior is out of station, your lordship.
Out of station.
Yes, your lord.
Item number?
What is the name?
J.K. Roy, your lordship.
Learned Counsel Mr. J.K. Roy, Vice Learned Counsel Mr.
R. Sharma.
R. Sharma has prayed for adjournment as Learned Counsel Mr. R. Sharma is out of station.
If your lordship
Yes.
allows, the matter may be listed on 18th, your lordship.
18 Pioneer.
19th. 19th.
19 or 20?
Deeply, your lordship.
When
19th.
do you want? 19 or 20?
19th.
List the matter on 19. 19 June.
Item 7.
Deep your lordship.
Hmm.
May I please your lord?
Hmm.
My lord, we have challenged the criminal case filed by against my lord, 9 persons, those who have booked the flat on their own land at Nagaon, my lord. And my lord, they have started the project of constructing flat at Nagaon, heart of this town, my lord. Now, my lord, this informant who claimed that his land is involved, he filed a civil suit. And I take your lordship to my lord, translated copy and
But you have stated that there 9 persons have lost this case? 9 persons
criminal case has been lost.
by 9 persons?
No, against 9 person by the so-called owner that his land is involved in the said building. Now, what honorable court below has issued a notice to show cause, but not issued any process. Show cause why his prayer should not be accepted. So, and date was given on 27/6 to appear. So, my lord, naturally we will appear. Now we have come to challenge this whole proceedings because under the grave of a criminal case, he cannot come to the civil matter. My lord, he has admitted that a civil case was there. I am reading page. Please come to take little pain to come to page number 19. 19. May I read, my lord, 19?
Yes, yes.
Most respectfully and humbly beg to state that on 24/18/2000 complaint purchased a plot of land measuring 1 kata 1.5 lesser from the accused number 2 Benudar, accused number 5 Deepak Das and accused number 8 Dipankar Das, which was under the name and possession situated in Nagaon Shodor Revenue Circle, Dimaguri, Kishan Nis Shahat Moja, covered by pattern number such and such and such, subsequently mutated in possession of the complaint. Additionally, for the purpose of the access of the said land, the complaint also acquired one L-shaped pathway measuring approximately 11 feet wide and 250 feet length through the registered sale deed from the portion of land under pattern number such and such. That my lord, on 26/18, the malicious intention and under greed, the accused person wrongfully disposes the complaint from the said land. So consequently, complaint filed before the honorable court at Nagaon, which is currently pending special LG case number such and such and such. That from the written statement filed by the accused, the complaint came to know that all the accused persons accused of 1 to 9 by colluding with one another and premeditated conspiracy to commit fraud, filed a collusive title suit being TS case number 7 before the honorable court. Therein on 4/9/17, the accused person fraudulently obtained a compromise degree by misleading the court and suppressing the material facts. Through the said compromise degree, this accused person included the complaint's land and later encroached upon it. The complaint was completely unaware of the said collusive suit of the degree. But if there is any collusion degree, the only remedy is civil court. He should come to the High Court or the senior civil judge. But he has filed a criminal case against that under what section? Section 4, the 318(4), 229, 336(3), 337, 339 of BNS, which is not applicable. My lord, apex court in a category of judgment, I am submitting, my lord, the dispute which essentially of civil in nature, it is essentially civil in nature, file a criminal complaint. Criminal court duty to check abuse in the process. Hell, criminal court should ensure that criminal proceedings are not misused for settling the score of pressurizing the parties to settle a civil dispute. But I am giving it to your lordship, peruse it, my lord. Your lordship will.
Just please sit down. I'll just I'll read completely that
Yes,
complaint petition. Please sit down for some time.
yes. May I read entire petition?
Yeah, yes. page 20.
Yes, I am
from
reading.
paragraph.
Yes, in the said decree, it was mentioned that by the accused themselves that the total land of the partner number such and such jointly held by all 9 accused persons. We are all jointly held. It is evident that the compromise decree was obtained illegally, fraudulently, and by misrepresentation, thereby misleading the honorable court. Accordingly, challenging the said fraudulent compromise decree and for the consolidation of the land illegally claimed, the complaint instituted TS number 9 now numbered as to, which is presently pending. Now it is pending with a special LG case number, TS number of sub judice, a builder group under the Royal Mission Nagaon Commercial Cum Apartment Promoter Reliable Associate, NH Center Point, first floor, opposite Borasarbi, Ulubari, GS Road, Guwahati, knowingly, illegally, and fraudulently with the intention of the deprive the unlawful profit, colluded, and the said accused persons, number 1 to 9, and initiated the illegal multi-story construction on the disputed land, that is partner number such and such. On 31 to the 30, the accused person, along with accused number 10, executed an agreement of development land and an irrevocable general power attorney, wherein the fraudulently exaggerated the land area from this actual 1 bigha 1 kata 70 lakhs to 2 bigha 1 kata by producing a forged and fabricated document, thereby misleading the Nagaon administration and obtaining fake approvals from the Nagaon Development Authority, the circle officer of the Nagaon Revenue Circle, and other concerned officers. The complaint upon the observing the ongoing construction of the Royal Mansion Nagaon filed an RTI application before the Nagaon Development Authority. Upon receipt of the document, discovered that the accused person illegally included complaints land under the Kolong River and other lands in the project by forging valuable document. The actual land under pattern number such and such, deed number such and such, it is falsely shown as 2 bigha 11 lakhs. Even in some official document, it has been misleadingly shown that 2 bigha 1 kata. Moreover, the written statement filed by the accused person in judicial case number such and such, Surajit De versus Putuli De and other before the Honorable Additional District Judge 2, Nagaon, it is falsely stated that they possessed 2 bigha 1 kata of land under pattern number such and such. Hence, it is evident that the Royal Mansion Nagaon Commercial Cum Apartment and 9 accused landowners have conspired and deliberately inflated the land area from 1 bigha 1 kata 7 lakhs to 2 bigha lakhs.
All right. Yes.
My lord, here it is
This CR case, my
it
lord.
is a complaint case, my lord. Here, Lordship may issue notice at this stage, and after
Notice
their
and further
appearance, my lord,
proceeding may
their
take.
appearance, my lord, Lordship will consider their appearance. It is
Further proceeding may take, my lord.
And we say,
no, my lord. Here, it is a complaint case, my lord.
Complete here.
you, you have given me this judgment. I have another judgment.
I've got another
No,
judgment. Supreme Court.
Recently circulated judgment.
Inherent power
No,
under
no,
the question of the FIR.
Recently circulated judgment, not question of the FIR.
Yes.
To
Well,
destroy illegally constructed building.
yes. Yes, man. But the criminal case won't lie. He has already taken the shelter in civil court. Matter is sub judice. How he has come and filed this criminal case?
Let them appear, my
Just to
lord.
stall our progress of the construction matter, which he cannot. And he has said that everybody we have gained over everyone. Development commissioner, circle officer, all we have been gained up. Which is absurd and absolutely false allegation, madam. And that's why learned court below has not issued process. Just the issue show cause. Why? This is also something peculiar. How the show cause has been given in the criminal case?
I'm not staying. Let us call for the records.
Please call for the record.
Then after the records come, then we will check.
Yes,
and
yes.
if
Your lordship call for that.
Third learned counsel, Mr. S.C. Biswas for the petitioner, Rajkumari Das, who has filed this application under section 528 of the BNWS 2023 with way for washing the CR case number 577 of 2025, registered under sections 61 to 29, 318 within bracket 4 bracket close 336 within bracket 3 bracket close. Stroke 337 of the DNS single S, full stop. It is submitted that the petitioner has been roped in a criminal case in the which ought to have been roped in a criminal case which ought to have been a civil case, and the Honorable Supreme Court has through a catena of decisions directed not to proceed against criminal cases in the garb of civil cases. Full stop. Heard Mr. B. Samalari, additional PP, Assam, for the respondent number 1 and has accepted notice. Who has accepted notice after comma for the respondent number 1, and thus no further notice is required to be issued. However, sufficient copies to be furnished during the course of the day. Meanwhile, issue notice to the respondent number 2 as per usual process, returnable on dated as detail. After vacation,
Yes,
also call for the scan copies of the trial court records. Entire trial court record.
my lord, should I give another judgment of apex court of 2024, 2017? I'm giving.
On that day,
Yes, yes.
on that day,
Development.
the prayer for interim stay shall be considered after receipt of the scanned copies of the trial court record.
May I please, your lordship. My lord, this criminal petition is filed for quashing the entire proceeding of my lord, special B case arising out of the my lord child marriage case, my lord. My lord, at the time of
Child marriage.
yes, your lordship.
Okay.
Now she is my lord, 19 years, 10 months. And one my lord, male child is
Stating that warranty was not found in the given address and no one, this is the reason. Then thereafter PNA has been issued, lordship kindly see. And lastly, the lordship kindly last order, page lordship kindly page 74. 74 also, no report has been come, page 75 relevant part, my lord. Page 75, my lord, relevant,
15
no,
Last
seven-
one was 15 by 1 month back.
my lord.
1 month back.
Yes. Then PNA, again PNA has been issued. Since received
Yes,
report,
yes.
so I will appear now, matter is fixed on 17/6. I will appear, my.
Matlab, let him appear, matlab, thereafter court will below consider as per.
I may be allowed to go on bail.
No,
Because I was already on bail.
no, you're not bill PNA issued, man.
Charges has been submitted.
Submitted, man.
Because I was already on bail.
Only 10 days time may be granted to appear and the court will consider, man, as per law, man.
Heard learned counsel Mr. J. Ahmed for the petitioner Rohim Ali Sheikh, alias Rohim Ali, who has filed his application on the section
Because that means I have not received any summon, any report
Yes,
I have
yes.
not received.
528 of the BNSS 2023, which prayer for setting aside and quashing the order dated 26/9/2024, issuing NBWA against the petitioner, as well as subsequent orders up to the order dated 15/5/2025, issuing PNA against the petitioner in connection with PRC case number 19 of 2023.
Pending in the court of JMFC Shivsagar.
Pending in the court of the learned JMFC.
Shivsagar.
Arising out of Shivasagar PS case number 26 of 2022 under section 353, 379, 279 IPC, read with section 13 of the Assam Cattle Preservation Act. First of this case is pending in the court of the JMFC Shivsagar. Heard Mr. B. Sharma, learned edition PP Assam. Full stop. It is submitted on behalf of the petitioner that the petitioner was not at all aware of the pendency of the case, as no summons had ever been served to him. Thereafter, NBWA has been issued against him, and finally PNA has been issued against him, and the case is fixed for report on PNA on 17/6/2025. Annexure.
My lord, page 69 is the first NBWA, the report, page 70. Page 69,
This will form a part of which annexure?
page 69.
68, my lord, issued
And-
fresh PNA. my
And
lord.
Fresh Pendles, page 60.
Initially 68, my lord. No report has been received yet on PNA issued against the accused person so and so.
The copies
Yeah,
of the orders of the learned JMFC Sagar has been appended along with the petition. And uh, first
Pa-
PNA,
Page 69, madam.
first PNA was issued by order dated 12/12/2024. The case was fixed for report on PNA on several days and finally on 15/5/2025. Fresh PNA was again issued against the present petitioner. The petitioner is willing to cooperate with the trial. I have considered the submissions at the bar with circumspection. I have also taken a pragmatic view. As the petitioner is willing to cooperate with the trial, the petitioner is hereby directed to appear before the learned trial court within 10 days, and cooperate with the trial. Meanwhile, the NBW and the PNA issued against him is kept in abeyance for 10 days.
I may well have to go and bill.
Huh?
I may well have to go and bill. That is there, that order can be passed. Now
About
it is.
petition, the petition stands disposed of.
Hello.
But on the last day, your lordship has given a lordship proposal regarding settlement.
Not, one second.
Advise me to take instruction, lordship. I have taken instruction from my client, lordship. So far the instruction is concerned, lordship. Actually, he has no debt and liability upon the complainant, but lordship, under compelling circumstances, lordship, will agree to pay, lordship, if your lordship, which the amount being fit and
How much?
proper. Lordship, he will agree to pay 6 lakh, lordship, because the
7 lakhs lordship, your lordship on that last day, offered the proposal that is 6 lakhs plus 1 lakh. But my lord, the petitioner has faced the litigation lordship for last 15 years. More than 2
15
lakhs
years.
lordship has already he spent. My client is also saying that I am not seeking more than that. If lordship, my client's lordship convinced that he is saying that 6 lakhs plus 2 lakhs, at least 2 lakhs lordship he has already spent for this purpose. So he is praying that to not more than this amount lordship is not.
lordship, one thing may I allow to submit, lordship. The complainant is the only a third person, lordship, who somehow collected or found this check, lordship. And no debt and liability upon him.
Now.
Somehow he collected, though it is not
Again,
relevant, lordship,
again.
because before this court, lordship, at the present time, lordship.
2 crores already he has lost. This is against concurrent February, your lordship.
Proceed with the argument then.
Yes, other.
Medical, medical. Medical,
Why decline for
I will agree to pay 6 lakhs.
6 lakhs of now. 6 lakhs of Telugu.
At least 50,000. He has engaged the council. He has paid fees to the council. He has lost twice.
Lordship, whatever the amount the honorable court will deem fit and proper, lordship may pass order. My
Whatever.
instruction was. But it is under compelling circumstances.
6,50,000?
50,000 will be so big, your lordship, because
I understand.
your lordship is aware that to 15 years he has faced this litigation. How much money he has already spent, including this high court proceeding. At least lordship 2 lakhs
Not,
he has already spent.
not legally enforceable debt, lordship. Even in the complaint petition, lordship, he has not mentioned the date of the giving money, lordship, loan, lordship. And even the month of the giving money of the lordship,
In the month of.
not mentioned in this complaint
That is,
petition,
yeah.
lordship.
First, initially there was the judgment and then it went for appeal. And now it has come before this court. You see, you don't have a very strong case. I don't know. You also don't have a very strong case.
No,
Today,
Lordship,
I am having also.
Two courts.
today, Lordship, I have come with another judgment. On the last day, Lordship, I have given one judgment that I have, Lordship, relied paragraph 14, 15 and 14, 15, 16 and 17. On the last day, Lordship, only
No,
we
but,
have gone through paragraph 17.
these are old judgments, very old judgment. These
I'm having in 2019 judgment, Lordship, in favor of me, Lordship.
I am also with the
respect to-
2021 judgment is there. Lordship, the Honorable Supreme Court is held that in addition to the amount, that is twice the amount of the Lordship check amount.
see,
Yeah.
when it has come under the scanner of
Simple
two
interest of 9% per annum.
I don't think he has a very good case. Maybe he may have a good case, but after being scanned by two courts, and now also I don't know. You can proceed with the argument there, but instead of bargaining, I think you better pay it. See,
I leave it to your Lordship, because I have placed Lordship as my client is.
I understand he will be
Because
paying. I
your
know
Lordship Lordship
15
cannot say.
lakhs it will be much more than 2 lakhs. How much he has spent on vehicles, on advocate, then mental tension, everything. If you assess in money, 2 lakhs is nothing. He has undergone much more trauma than rupees 2 lakhs damages. So
On the last day, your Lordship,
I asked for 7 lakhs, but he's not willing to pay.
he has the capacity, he cannot say.
Oh, Lordship, at the verge of Lordship.
He has
62 years
already
now.
Lordship caused loss to the complainant, Lordship, this petitioner. Who is liable for that, Lordship?
650,000.
I have given the consent, I have Lordship. Huh? Lordship can be on 7 lakhs, Lordship, that is, I think that will not burden
Okay,
him.
then 7 lakhs.
People something more, Lordship. As per
He will
instruction, Lordship, I
say
will.
something is more, but he should know what.
What is
No,
what is your client doing? What is his employment, profession, business?
Earlier he has truck, Lordship.
Truck.
Now, Lordship, he is under age of Lordship 63 years now available.
He is now
62 above Lordship. Yes, above Lordship. He is,
62 years.
Lordship.
Now he doesn't have a truck. Or maybe 2 trucks.
Lordship, business is
And one.
fallen down, Lordship.
Huh?
So if 650 is Lordship, reasonable, Lordship. Because Lordship, he is completely a third person, Lordship. As per instruction, Lordship. I consulted with him, Lordship, about this matter, Lordship.
Obviously,
6,75,000, otherwise I'll proceed for hearing. 6,75,000, otherwise I'll proceed for hearing.
6 lakhs,
75,000.
then Lordship, given Lordship, maybe given Lordship.
Hearing,
Lordship, as your Lordship. Fit, even proper Lordship.
my lord, that amount matter may be kept pending, at that amount maybe some time may be given within that time, Lordship, they may
he
deposit that amount.
doesn't want to pay. He's saying I'll submit my hearing.
Yes.
He's not paying.
Procedure.
He said,
He's not paying 6,75,000.
"Oh, yeah,
He's
I'm
paying-
I'm not saying that within 1 week, Lordship, he will obviously take some time, Lordship. Your Lordship may give a reasonable time, within that time he will pay, and then thereafter, Lordship.
When order is passed, Lordship, I will bound to pay, Lordship.
You'll be paying
Yes, Lordship.
6,75,000.
Lordship,
Okay, all right then. Third learned counsel, Mr. B. Uloskar. For B. Uloskar,
B. Uloskar.
for the petitioner and learned counsel, Mr. M. Khan. For the respondent, it is submitted that both the parties have amicably settled their dispute and the appellant, petitioner,
Revision.
and the petitioner, what is his name?
Abdul Mateen Barbuya.
Petitioner Abdul Motin Borguia is willing to pay rupees 6,75,000 to the petitioner, which is alleged to be alleged to include the check amount of rupees 6 lakhs along with the compensation of rupees 75,000. All right. So I'll give you some time.
Yes.
This matter on when do you want?
Lordship,
When do you want? I'll give you some time. When do you want to pay?
I will fix after 1 week for
After vacation?
yes,
List this matter on, I'll give you a date. 18 July.
and in the meantime, Lordship.
Okay.
may not be possible, Lordship, for me, Lordship.
We'll list this matter on 18 July. You agree or you won't agree?
It is the more than.
Few days later, Lordship, I will.
Yes, we'll list this matter on 18 July. Then you both file a joint agreement.
Yes.
Submit a joint agreement to pay within complete payment within this type of months. And if agreed, it's okay. If not agreed, we'll proceed with the hearing.
Lordship.
Well, this criminal petition has been preferred against the order passed, impugned order passed on 16/5/2014 regarding non-giving of the Jimma of a phone, my lord, mobile phone, my lord.
Okay.
So my prayer was rejected in
You
the
are
trial.
accused. You are an accused.
I'm not actually, I'm not an accused. I'm the wife of the accused.
Wife of then you are?
I
Appearing for the state as a special people.
No,
Special PP, my
for
lord.
state. NDPS case.
No. PCF case, Prevention of Corruption
Okay,
Act
okay.
case. My husband was working as a officer in charge of Dhola PS case, my lord. And in that event, he was using my phone for some limited purpose, wife's phone. Because his phone was out of order, so he was using my phone for a limited period. So that was seized. So I applied for it. Till date, my lord, of my seizure, as on today, my lord, 2 years, 6 months, 27 days has passed. FSL report has not come. So today is the date fixed for report, and my learned friend will be probably submitting a report which will be definitely not to give in favor of me. But whether a situation wherein my mobile was seized some 2 years, 6 months, 27 days, till date they have not procured the FSL report. So what is the purpose of retaining it? That is my preliminary submission. Let's see, hearing what he has got.
Lots of, the FSL report has been received. FSL report has been received. Only the thing is that this is the primary evidence, so far as the mobile device is concerned. So on the reported trial court, we have raised an objection. So far as the FSL thing is concerned, it was reflected in the charge sheet as well.
No.
The only difficulty is that that was expected only. That is the
No.
That is the prayer given
No,
by the
no.
Nisha Bora.
I'll show you.
Your Honor may kindly look at page 71 of the impugned
Page
order.
35.
Page
No,
71.
my petition, page 35, kindly
Please.
see, your report says, FSL is yet to submit the report. FIR
Just-
report on
just-
extraction of data and mobile phone.
No, this is regarding the Galaxy.
Hmm.
Galaxy.
Wait, wait.
Just a.
So,
Extracted at VFS. This is the report which was submitted
That
by
was- The report may be wrong now, record
No.
must speak, my lord.
this is the report submitted by the
I will
IO.
submit report in a routine manner, my lord.
No, no.
If the-
can you read out the report?
Yes, yes, please.
Everybody can hear it. On quit it.
On last occasion, the High Court sought a report. With reference to the subject cited above,
वही तो Galaxy की लगे, Wi-Fi. Wi-Fi.
Advocate for the petitioner, Mr. Z. Kamar has submitted for time to
The
place.
report is also.
What do you want to submit?
I'll submit, my lord, the certain legal proposition which I'd like to lay down on the next date, my lord.
To,
That how clone copies can be made and used as an evidence, my lord.
to place his submission regarding to, to certain,
Tell about what.
to some guidelines of the Honorable Supreme Court, as to how clone copies may be made, clone copies can be made, so that the mobile can be,
Remember, yeah?
clone copies can be made so that the Zima of the mobile may not hamper the evidence. Hard learner counsel, hard learner special public prosecutor.
J. Hassan. It is not Jade Hassan as reflected in the cause list. It is J. Hassan.
Javed
J.
Hassan.
Hassan.
J. E.
J.E. But
No,
for Z.
J. E.
J.E.
J. E.
Javed,
J.A.
Javed Hassan. Not
Hassan.
Kamal Hassan.
List this matter on 21. Next, after view,
Uh,
after
after
summer
vacation.
vacation.
After vacation,
List this matter after summer.
on
vacation.
15th July, if the
Eh, July
kindly
ko ado.
picks up a date on 15th
Date
July.
of the
My lord, let it be on 27 of this month, my lord.
27 of
7th of
7th
June.
This 7th of June is date will class
last day, I think.
Oh, take it. Okay, my.
Last day.
No,
15
July.
no, 15th, I'll be problem. Let it be on the 17th then.
17
7th
July.
July. Hello.
Lordship, today we have some difficulties, so the matter may come up on Monday.
In this case, record will be required, madam, whether they receive notice or not.
One 125 proceeding,
Yes, Lord.
Yes, madam.
we'll need a record.
Record will
Final
be required
judgment.
because they are only ground, my lord, they did not receive the notice.
Ex parte order.
As per the order.
Yes,
Ex
madam.
parte order.
So whether they have received the notice, it will be clarified in the record, madam. If they received the notice, then remain absent, then matter would be different.
That you're paying the
No, nothing has been paid. About 2 lakhs, my lord, is due.
scan copies called to live Malazani as per the order. Learned Counsel Ms. T. Hussain, no?
T. Begum.
T. Begum is present on behalf of Learned Counsel Mr. R. Rashid and R. Rashid. Oh, Mr. A. Rashid and is submitted for time to place their submission, full stop. Learned Counsel Mr. H. Ahmed.
R. Ali.
R. Ali is present for the respondent. Call for the scan copies of the trial court record. List the matter after vacation.
And my lord, they may be directed to pay.
Not now, Lord.
That-
After,
will direct.
after receiving this.
Scan
Apply.
after vacation.
Lost.
List the matter after vacation, summer vacation.
Apply.
May I please, Your Lordship? Because the appeal is against my lord judgment order and the judgment dated my lord 3/4/25 and order dated 7/4/25.
Posco.
Well, not POCSO, my lord, it's under 374.
Immoral Traffic Act.
Immoral traffic, my lord, under IPC. my lord,
All right.
certain.
We'll admit it.
My lord, I have the IA for my lord suspension of this. sentence, my lord,
Suspension.
and
How
for
many years is the sentence?
10 years. my
10
lord.
years.
10 years. You have filed objection? No.
We'll have to file, my lord.
We'll
Here,
have to
today is
file.
first, my lord.
First,
First
is
day,
in
my lord.
motion stage.
Admit, my lord, admit the same
Admission
call for
stage.
report, my lord.
We'll admit it. Learned Counsel Mr. U. Soikia, no?
Use this, yeah.
Mr. U. Soikia is present for the appellant who has preferred an appeal
Mandatory.
against the judgment and order dated 7/4/2000 and 3/4/2025 and 7/4/2025. Whereby and where under the appellant was convicted under section, how many appellants?
370,
Subsection 4, my lord.
One appellant or how many appellants?
one appellant.
You have for one appellant.
Matlab, only one person has been
Okay.
convicted, matlab, others were given matlab, released on
Acquitted.
acquitted matter.
Convicted and convicted under section 370 within bracket 4 of the IPC. And sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000 with default stipulation. Admit. Learned additional hard learner admitter agot likhi diya, hard learner additional PP Mr. B. Sharma for the respondent. Admit. Call for the trial court records. List after the vacation.
Matlab, date may be fixed.
List on. IA to লিখা একেখিনি লিখি দিবা এডমিট নিলিখিবা খালি learned additional PP has submitted for time to submit his objection.
My lord. It's for some time to file objection. We have not yet filed. my lord.
Has prayed for some time to file his objection against the application. It I to admit to nilhi by it.
Much.
Item 16.
May I please? Lordship, here in this case, Lordship, the charge sheet has been submitted, Lordship, in the year of 2020, Lordship. And the FIR was lost, Lordship, 11/3/2019, and my name is not in the FIR also, Lordship. And even then, Lordship, and section is, Lordship, in the 120B and 381 of IPC, Lordship. But in the only, Lordship, my name is in the charge sheet, Lordship, and kindly come to page number, Lordship, 27.
My lord, here charge sheeted case, my lord, lordship may call for trial for record.
32.
Without the record,
Moment,
my lord.
Lordship. Otherwise, there are 5 numbers of seizure list, Lordship. Nothing has been recovered from my possession.
No,
Nothing
no.
has been recovered from me. Only my name is in the incorporated in the charge sheet.
How
When
here is
the
his name is in the
judge
charge?
Stay in the first date.
Lordship.
First date it was before the court and court has returned a
So, my lord,
good
here in this-
elaborate order, but nothing about stay.
Lordship, one problem is
And
here,
now why in the midterm you want to stay?
Lordship, my
during
submission.
admission?
Lordship, in this case, Lordship, there are 6 numbers of accused, Lordship.
You are on bail, no?
Lordship, and the initial
See,
stage.
you see, why didn't you place your submission for stay on the first date?
Lordship, just
Elaborate
for a
order
moment,
and
Lordship, I am
then-
appreciating Lordship. Here in this case, Lordship, there are 6 numbers of accused, Lordship, and charge sheet is submitted against 6 number. But Lordship, and the other 3 and 4 accused, Lordship, they are not appearing since 2020 till today, Lordship. Only 2 and this present petitioner and other one is, and sometimes he is appear and sometimes he take a adjournment, Lordship.
No, I didn't
No, my lord,
understand.
I have been-
why- I cannot understand why, at that time you didn't pray for stay and why this submission now?
Lordship, and this year, Lordship, that is why, Lordship, since 2020 till
No,
today, no charge was framed, Lordship. And even then, Lordship, the other accused is, even then petition was filed for a split up, Lordship, the court did not comply this petition, Lordship.
In this case, is pending at which stage?
So, my lord, Lordship,
Which stage?
this SDGM 1 come to Metro, Lordship.
No. At which stage?
At appearance stage, Lordship.
You don't want to appear.
Lordship, sometime I may appearing, Lordship, but the other accused is not appearing.
My
That
lord,
is why
he is appearing, my lord. He is challenged the charge sheet, my lord. How he is without record, my lord.
For a moment, Lordship,
And
kindly come to
his
page
name
number
is in the charge sheet, my lord.
32, Lordship. For a moment, Lordship.
What happened on 19/5/2025? Why didn't you pray for stay there? Now you're stressing.
Lordship, someone
On
is
stay.
after 2-3 years later, Lordship, someone is received by this petitioner, Lordship.
No,
But he is
I'm
also-
saying it was before this court on 19/5, before another bench. That time you didn't press for stay. And now I
I'm
am
not-
pressing for stay.
No, sir, it is second time, Lordship, and today is.
So
In the first time, not.
why press or?
Earlier
it was
also,
another
Lordship,
bench
not,
and
not,
now-
Lordship, no, Lordship,
Because-
earlier also.
Because it is before me and I keep on hearing.
No, Lordship.
Recently.
Earlier also I made submission, Lordship. Similar submission, Lordship.
So why it was rejected then?
No rejected, Lordship. The scan copy
Scan
was
copy was
not-
called for, my lord. Today, perhaps it is not received.
Scan copy is not called. Okay, yes, call for. Scan copy is called for is not received. Issue reminder list the matter on. We'll give you a date. 15 July,
16, Lordship.
16 days.
Obliged.
May I please, your lord?
Mm,
That case, my lord,
That case,
that, my lord, from Silchar, my lord.
I forgot.
My lord, the
exactly the
petitioner,
case.
he is a convener of a group called Barak Development Front, my lord. Then, my lord, when these assembly constituencies were delimited, my lord, they filed an objection to that. They had an objection and, my lord, they called for a bond. Lordship finds. Thereafter, my lord, they withdrew the bond, my lord. They had taken a decision and, my lord, there were some other political parties also who had, my lord, taken the decision to call for a bond. And if your lordship sees, my lord, page 28. May I place page 28, my lord? A
I'll
Barak
come
bond,
back after 5 minutes.
my lord, yes,
I'll come back after 5
yes,
minutes.
yes,
Because I'll be hearing this, no?
yes,
My
my lord.
Lordship, in the by earlier order, Lordship called for the case diary of the particular Korimganj, the PS case
Yes,
number.
yes.
That has not yet been received. And
We
the
need to
next date
see-
of the
If that
case.
has not been received, my lord, I'll pray for him, my lord,
Lordship,
in
my lord,
order
next
to
date
stay
of
the
the
further
case is,
proceedings, my lord.
1st July, my lord. There is a date, next date is 1st July, and Lordship has already passed the order that he can seek adjournment on the next date. As the
No.
next date is 1/7, my lord,
No,
Lordship may fix it on case on 23rd or
Yes,
like that
yes.
way.
No, my lord,
On
lordship
10th,
will see
my
the
lord,
first order, lordship will see the first order of
Yeah.
this case.
The-
My lord, it was a direction from this court that on the receipt of the LCR, my lord, on the records, that my lord,
Lordship will
prayer
look into
for
Lordship's
interim stay.
order.
No matter what is his problem, my lord?
Not received it. See, give me some time. This is
Yes,
from
ma'am, please.
Korimganj, no?
Korimganj,
Korimganj,
my
my
lord.
lord.
So,
On 10/6,
last day
registry wrote
before
it, my
the,
lord.
last day before the
The
vacation,
23rd or like that way,
we'll
my
need
lord.
at least 2 weeks from Korimganj. If too earlier date, it won't come.
So,
Last
it was given as per the convenience of the PP, my
No,
lord.
my lord,
He
it is
sought
a-
for the date, my lord.
No, my lord, registry
He
wrote
sought
it,
for
my
the date, my
lord.
lord.
You can look into the
27,
registry.
27.
No, lordship, lordship, come back, my lord.
No, no,
I'll
no,
pray
no,
for
no.
it, my lord.
I
Interval.
won't come here and go.
No.
27/6.
No, my lord, please come down, my lord. I have
No,
also,
no.
my lord, my submissions may also be heard, my lord. Why a man is being harassed like this, my lord?
No, no.
Kindly
no.
see whether the legality and validity of the entire thing,
No,
let me place, my lord.
See, it won't, I know, because you see, this is too short a date from Korimganj. It
No,
won't
that
come.
was given by your lordship and on in his insistence, my lord.
Registry
No,
wrote
that is not my fault, my lord. On
No,
two
no,
occasions
no.
I have appeared, my lord.
My lord,
On the last occasion, my lord, let me speak. On the last
Registry
occasion,
wrote
my
it
lord.
on
Now,
10/6, my
now,
lord.
now I'm giving you
It
a
is the
date.
12th
My
only
lord.
today.
If it comes or it
Yes,
doesn't
my lord.
come, we'll consider.
My lord, no, my lord.
Only
When the
one
record
date, one
comes,
date,
when my lord, the
27.
record, kindly listen to me, my lord. When the record comes, it will be fixed for a final hearing. Today, I am, my lord, before your lordship.
No, no, no.
I have given all the records, my lord.
No, I'll
See,
be-
kindly, my lord, why is,
submission, I'll
my
give the
lord,
records.
why I am not being able to satisfy your lordship, my lord? A 70-year-old man, my lord, is tied up in this case. We have nothing against him, my lord.
He is not behind bars. No, he is not behind bars.
No, he may not be
And
behind bar,
next-
but for dragging a man from Silchar to Korimganj, my lord, why will you drag, my lord? Because what is the law, my lord? Even the law, my lord, kindly consider, my lord.
No, no.
No, my lord, kindly consider, my lord.
You cannot see how.
No, my lord, I am not. No, I am arguing my case, my lord. Kindly consider, because if your lordship sees the first order, my lord, the first order, this court, my lord, stated that on the receipt of the, my lord, records, my lord, that it will be considered.
Yes,
My lord.
it has not come. No,
It
the
has
next
not
date
come,
is
so
on
part
7th.
of the record has come. What I am trying to show before your lordship is, my lord, kindly see, my lord, some records have come.
But I'll need a CD, no? This is under
Lord, the CD has not come, but kindly consider one aspect of the matter, my lord.
No.
Kindly consider it from my side also, my lord.
See, that is why I'm
Let
saying.
me at least substantiate you, my lord, as to why, my lord, I am praying so much.
You see, every day I cannot hear you at length. That day I heard you at
No,
length.
you did not hurt me in length, my lord.
I heard you at
Lord,
length.
that day, lordship fixed up your mind, saying that, my lord, let the CD come. It will be required on his prayer, my lord. The CD has been called for. The scanned copy of the CD has not yet been
Premier
received.
petition, you see, you have the CD?
My lord,
Bail hearing, CD?
My lord, FIR please.
Just a moment, I'll need the CD.
it is 1 week.
1180/2025? No, no CD. We'll need the CD. CD has call press not receive issue reminder list the matter on 26 June.
26.
Item number 21 for order.
Where do you was?
Costco Bay.
Lordship. Lordship, my senior is.
No, no Fox madam.
Not-
Not Fox madam. Major 27 years old madam. The plate. Your lordship, they are having very limited scope on a PP is there, my lord. Hey, to me, as an PP.
PP.
Madam, your lordship kindly see, my lord, see, just I have also annexed the FIR also, my lord. Your lordship kindly see, my lord. That's,
You're behind bars for how many years?
madam, 1 year, 6 months, madam, more than 6 months.
1 year.
About eight months, madam. 9/11/23.
9/11/2023.
9/11/23 judgment.
And since then you are behind bars.
Yes, and she has on her own mother. She is an employee. I am also employee. Yes, madam. So we are having some relation, madam, that is admitted. And she has gone along with him.
Being fact, my lord, there is a report submitted by the process server of the CGM office, my lord, Jorhat. He has visited the place, with the address, my lord. He found that the house has been lock and key, my lord.
Then he came to the house of the Gaubura, and Gaubura has said that presently, since for last 3 and 4 years, my lord, they were used to live anywhere, my lord, sometimes in Guwahati, sometimes in Jaji. And now, my lord, therefore, my lord, the service has not been completed. And now, my lord, they are used to live at Jaji, my lord. We have got the present their address, my lord. We may allow to take the trace steps to that Jaji, my lord.
Learned Counsel Mr. P.K. Bodle.
Ji Burwa, my lord.
Learned Counsel Mr. D. Borwa
Yes.
is present for the appellant. It is submitted that steps were taken and the process server's report reveals that the the respondent number 2 could not be found in the given address. Respondent number 2
Yes.
could not be found in the given address as the respondents shift their residences and sometimes they stay at Jaji and sometimes they stay at
Anyway,
Golaghat
at Guwahati and also.
or at Jaji or at Guwahati. Golaghat, no, Guwahati. The present address of the appellant has been respondent number 2. The present address of the respondent number 2 has been obtained by the appellant. To stop appellant to take steps to issue notice to the respondent number 2 in the present address, returnable within, as per usual process.
Yes.
Returnable within 4 weeks.
Yes, my lord, I have filed another case, my lord, for IA for bail, my lord. What happened, my lord? The petitioners has been arrested on the date of the passing of the judgment and order. My lord, they have been arrested on 15/6/2024. Today is the 12/6/2024. Almost, my lord, 1 year has been done, my lord. While this case has been admitted, my lord, appeal has been admitted, my lord, your lordship has observed that the interrogatory application will be considered after receiving of the LCR, my lord. The LCR has come, my lord, already, my lord. My lord, 24/7/2024 lordship's order, my lord, in IA. My lord, already, my lord, the LCR has come, my lord. At that time, my lord, lordship observed that the interrogatory application will be considered after receipt of the trial court record, my lord. The record has come, my lord. He has already, the appellants were since 15/6/2024, my lord. Today is the 12th, my lord. Only 2 days is left for the 1 year, my lord. We may be allowed to go on bail, my lord, since appeal has been admitted by order dated 24/7.
20 years.
4 years, my lord.
এইটো এপিলতে লিখি আছিলে ন আৰু এটা লাইন লিখি দিয়াচোন এপিলটো part Miss N Das learned edition PP Assam post. Now we'll take up the IA. Lordship, do you have any objection?
Yes, Lordship, in medical report, Lordship, injury with their Lordship, located only in the scalp, Lordship, bone fracture of
My lord, it is
leg,
true, my lord.
Lordship.
There is a grievous heart as
Lordship,
per report, my
evidence of injured victims supported by the other PWs, Lordship, as well as for.
Who is the injured person?
My lord, here interestingly, my lord, in this case, my lord, in this
PW2, Lordship.
PW2. Just a moment, I'll just read the evidence of PW2 and the evidence of the medical officer. Thank you.
I have also flag marked the injury report, Lordship.
come next month. Let
My
them
lord.
stay for a few days.
My lord, what happened, my lord, in this case, my lord, only, my lord, the interested witness has been
No, no,
examined.
it's okay. We'll grant you bail, but not today.
My
You
lord,
see, they are so aggressive.
no, my lord, actually what happened, my lord, in this case, my lord, the police says the person has been hit by the lathi, nothing has been recovered and nothing has been seized, my lord. That is in our
No,
judgment.
that is the
And-
merits,
and-
merits of the case. We'll
actually, I'm
take them up in the.
My lord, I am coming to that, my lord, the Supreme
No,
Court.
but if they go out, then again they'll start hitting.
No, my lord,
after
they are
1
not
year.
living there, my lord. That is not happened, my lord. Already appeal has been admitted, my lord. 1 year has been gone.
They are unable to live there because of these people. How aggressive they are.
My lord, that is not a question, my lord, because already been they had been convicted, my
No,
lord.
but,
They were behind the
Their
bar.
entire family,
Lordship.
because they are scared of the family of these two brothers.
No, they are not living there, my lord. They have, my lord, as per kindly peruse the groundwork report, my lord. At the time of the incident, they were not live there, my lord. They were not live there 3-4 years, my lord. The incident has taken place in the year of 2023. Prior to that, my lord, they were not live there.
I'm not hearing the appeal now, no?
No, but
not
I'm
hearing-
just trying to satisfy your lordship, my lord. That's why, my lord, I am saying that, my lord, at this stage, my lord, already 1 year they have been behind the bar, my lord. At this stage, my lord, can you let them go and bail, my lord? We will taking all the any condition, my lord, on any condition, my lord, imposed against us, my lord, we will comply all the imposed. If we will not comply all any kind of condition, my lord, the bail may be automatically become infructuous, my lord, cancel, my lord.
I think they deserve bail next month, not this month.
Next month, my lord, that is 1 year and more than, my lord. That's why, my lord, they were unnecessary, my lord, they were in there, my lord. This appeal has already been admitted. LCR has already been come, my lord. Kindly fix the matter for hearing, and in the meantime, I
Okay,
may
just before the vacation. I'll take it up and I'll grant bail, just before the vacation, not now.
just before the case on.
List this matter on or to the vacation now got date এটা গেছো কোনটো like on 26 returnable on 26 লিখি দিয়ে list this matter on 26 June. There in the appeal that they need not appear. Informants need not appear in the appeal. Is it required? I don't think so. If they don't turn up, then
Not
we will hear
required,
the appeal.
Lordship.
Huh?
Required.
Not required.
Required?
Not required.
Not required. We'll hear the appeal then together.
Lordship.
My lord, actually, what happened, my lord, the
Before vacation, we'll hear the appeal.
appeal.
Yes.
My lord,
Before vacation.
because, my lord, in the appeal or judgment, my lord, and they have lost the affair, individual affair, my lord, not the police affair, my lord. That's why, my lord, it is necessary because Supreme Court says that if the wife is victim or any person of the family member has lost the affair, at the time of the appeal, my lord, they must be heard, my lord. If they have any objection, maybe they are, my lord.
Complaint case.
They are the complainant, my lord.
Not an FIR.
FIR, my lord. Individual FIR, my lord.
No, in
Originally, they have lost the affair, my
they are
lord.
not required to be heard.
All right, Lord. It is up to you, Lord.
Hear the appeal.
The final hearing after vacation, Lordship. After vacation.
On
for final-
26, my lord. 26, my lord. Already, my lord, 1 year has done, my lord.
Time হবো নেকি appeal শুনিবলে? নালাগে। Appeal শুনিব নোৱাৰিম।
Just on the reopening of the vacation, Lord.
On order, otherwise we will fix it for order 26 D to D.
26 on-
Order যদি আহক। We'll hear the bail application.
Lord.
On 26 only bail application.
দুইটা 26 দি থৈ দিয়ে। একেলগে with লিখি না 26 দি থৈ দিয়ে। একেলগে দি দিয়া order টো।
Oblige, your lordship.
My lord, in this case, my lord, we peruse the office note for a moment before I start submitting on the merit of the matter, my lord.
Service report is surveyed.
Office note.
Lord, it appears that it has been handed over to by 18/1/2025. The office note, my lord. It appears this that copy of EA has been handed over to learned APP.
I will take instruction, Lordship.
My lord, if my lord wants, I have only small prayer, my lord, because I understand maybe the court is in the mind that service has not been completed. So I'm not submitting on the merit. I'm just submitting on two facts, my lord. My lord, one fact is this, it is already 4 years has passed in this case and he is under conviction. One more small fact, my lord, which has been told to me over telephone is that there may be an angle of alibi which is not explored, at the time of trial. What I'm requesting, my lord will give me some time to file an affidavit to this effect because I was not conducting counsel at the trial stage, my lord. This
Affidavit
fact
in
of,
the IA or in this case?
my lord, in the maybe it will helpful in the IA also in the EA also because my lord will just allow me and file an affidavit. That's all. My lord will not record, but because this is instruction is coming over phone.
You want to take the instructions, today you'll take the instructions or I'll fix a date?
Fixed a date, Lordship.
Huh?
And you fixed a date, Lordship.
Fix a date of Lordship. Office note dated 18/1/2025 indicates that, notice, service of notice on respondent number 2 is awaited. Huh?
My lord, it can be written as awaited only to my limited understanding.
It was awaited.
It is awaited only, my lord.
Is awaited,
Yes, case number two.
learned additional PP may obtain instructions if notice has been served to the respondent number 2. List the matter on. Yeah,
Vacation ले दे.
vacation आगे के दीजिए.
After vacation, Lord.
After vacation.
Lord.
Okay, after vacation. 16 July.
My lord, not immediately after the
Okay.
reopening, my lord. I have something after 22nd if it is
22nd,
convenient.
yes. 24, yes.
Deep level, my lord.
Parties are represented in here.
In this case, lordship, appellant was convicted under section 376 and 366
Under
of the
section?
376 and 366 of the IPC. And he was acquitted from the charge under section 8 of POCSO, lordship. Lordship, kindly have a look.
Hearings. 24 July or shorter date?
Shorter date perhaps because this was fixed for hearing in May, my lord. 15 July.
15 July next.
I'm deeply obliged, my lord.
Item 27. In the hearing column, declare for hearing.
As per last order, lordship.
For hearing in the hearing column, making more specific.
Yes, otherwise otherwise it will come again on orders.
As per last order, lordship, notice was issued.
Office no? Service completion?
As per office note, service is not completed.
Service report on respondent number 2 is awaited?
Yes,
Yes. List on 21.
a short date may be given
Short
because
date is the video?
see if they not appear, then amicus will be appointed.
25th of June?
Lordship, obliged.
Item 28.
No, this IA was filed for the bail of the accused person
Hmm.
who is under detention because of the conviction of 7 years, my lord, 304B, my lord. My lord, doctor said that, medical
We
evidence,
don't
said-
need the LCR.
LCR not received, ma'am.
We'll need the LCR.
Ma'am.
Very sorry. LCR is called for is not received. Issue reminder, list the matter on.
within this month possible.
Yes, I will try. Last date maybe. Because this
One day,
LCR,
one day before last, my lord.
LCR will be coming from Sri Bhumi.
Yes, Sribhumi is not so far. My lord.
I know better.
Yes, you lord, you was there, I know. 26.
26.
Number 7.
Is it correct?
Oh, do you do that also? Oh, बाकी नहीं. Oh, দুটা বজাৰ fix কৰা কিটা বাকিটা মাতি দিয়ক. Item number 29.
Lordship, the learned counsel is on legs, may it be taken up on at 2.
At 2 we have other 2 matters fixed.
This is for hearing, your Lordship.
At 2 we have other 2 matters and so we won't be able to complete those 2 matters today. So you can take adjournment.
Okay. So this is our matter is listed for hearing, Your Lordship, the first item.
You
So-
can ask your you can ask your senior,
Yes,
but at 2 we have 2 matters for hearing,
okay,
2 matters.
okay, okay.
So we won't be able to complete those 2 matters. We won't, by 4:30, I don't think those 2 matters will be over. And the third matter, I won't be able to absorb also.
Which are the two items?
Hmm?
Okay, okay, okay. Okay, then Lordship, I'll get a,
Okay,
consent from
you
that.
come back at 2 and then
Oh.
you tell me if you want an adjournment, otherwise you'll have to wait.
Okay, okay, obliged.
Well, the matter pertains to quashing of an FIR, my lord. The petitioners were convicted under section 14A of the Foreigners Act, section 12(1)(c) of the Passport Acts, and added 370, my lord. My lord, here the FIR is at page number 45, my lord. Basically, the brief facts, my lord, is that these are the Myanmarese people who have taken a refugee card from UNHCR.
Hmm.
They have a valid refugee card, my lord. Now, my lord, if my lord may peruse the FIR, my lord, which is the relevant portion is on page number 47. If I may read, my lord. The brief of the case is that on 29/5/2022, complainant lodged an FIR at the PS to the effect that 29/5/2022 at about 2:30 a.m. The complainant AI Samir Uddin Lashkar, along with the staff of Town Branch Silchar PS, intercepted 3 vehicles bearing so and so, along with the passenger at Janigan Silchar, who were suspected to be the foreign nationals. Accordingly, the passengers, as noted below, were asked to give the relevant details regarding their identity and antecedents, which they failed to produce. Further, on thorough interrogation, they revealed their origin to be from Myanmar with their residence under district Ikap, Myanmar, and went on to the Silchar town on the aforesaid hired vehicle. Hence the case. My lord, there is no criminal antecedents in here, except for that they don't have validity. In spite of having that UNHCR card, my lord, they have not given us the opportunity to speak because there are language barrier between the police officials and the Myanmarese people, my lord. It's the wrong year. Now, my lord, as such, my lord is very well aware that, my lord, India is not a signatory of UNHCR, but it
Not at all.
but it respects the UNHCR and international convention, and it draws the inspiration from the international community, my lord, which may not be conflicted with the municipal laws. My lord, here the case is all about the UNHCR card, prior to the expiry of the UNHCR card, my lord, they were arrested, my lord. There's no such criminal activity down there, my lord. And my lord,
They are on bail now? No, they are behind bars.
they are behind bars, my lord. They have applied for bail
Motia.
in Silchar, my lord.
In Silchar, okay, not in Motia, not in
No,
detention
no, no.
camp.
They are behind bars. The bail was given, but the bail bond was not able to give, my lord. They were unable to provide a bail.
They will bail bond.
Yes, my lord.
Who will be there?
Yes, my lord. Exactly, my lord. So they are still behind the bars, my lord. And my lord, even
This is
though
an offense. How can we, this is an offense. They
My
are
lord,
not
but
supposed to
I
be
want to place some judgments with regard to the same, my lord. If my lord may,
Lordship, long discussion, long arguments, Lordship. May I please, the Lordship, we have received the LCD, Lordship. But after going to the CD, Lordship.
must still not.
Just a moment, yes,
but
just a
till-
moment, just a moment, yes.
After going to the CD, Lordships, I found Lordship there are some statements wherein there are even some petitions are filed from the IO Lordship regarding aiding of some section of IPC Lordship. But whether those has been accepted by the trial court by the court below or not, Lordship, that is not here. That I have to confirm. So Lordship may kindly fix this matter after some few days so that I can take instruction from the IO Lordship whether those
Any of some section.
My lord, what has happened, my lord?
because if those say IPC section
This
is
case is under investigation now.
under investigation.
My lord, what has happened, my lord? They have been arrested on 29/5/2022. Since then, they are in jail.
See, I'm telling you, you have a better option. You see, many have filed a writ petition for safe uh, safe route, I think, route or there's a proper word I exactly forgot. For safe route to
To
get,
UNHCR Delhi.
yeah, going to Delhi and thereafter sending them to the
Prescribed authority or
the countries like Germany who are allowing
No,
refugees.
either they are deported to the their own country or
For proper deportation.
the prescribed rules has to be followed. That judgments also I'm
That
followed,
is
my
the
lord.
better way, I think.
I'm followed, my lord. But my lord, what has happened now? 29/5/2022, they have been arrested. Till date, it has, as per Foreigners Act, minimum 2 years of imprisonment, maximum 8 years of imprisonment. Till that charge sheet has not been filed, my lord. Till that charge sheet is not filed.
When was it, when was the case registered?
The case registered, the FIR is at 29/5/2022, and since then they are arrested, my lord. Since they are in the behind the bars.
Okay. Since the lodgement of the FIR.
Since the lodgement of the FIR, until date the charge sheet has not been filed, my lord. Even it's been more than 3 years down the line, and they're still suffering, my lord.
I think.
My lord, I will place one judgment word
I think
of this
case
honorable
cannot
High
be
Court.
quashed.
My
Cannot
lord,
be quashed.
I will just place the one judgment of this honorable High Court, my lord. My lord, in paragraph 11, my lord. After hearing the, if I may, my lord,
Yeah,
after hearing the learned counsel for the parties and considering the entire aspect of the matter and considering the refugee certificate under number so and so dated 4/8/2010, issued by the UNHCR by its New Delhi office, issued in favor of the petitioner being valid up to 19/8/2000, as well as the communication issued by the Superintendent of Foreign Registration Officer Guwahati City under memo so and so dated, which are not in dispute, and on the finding of the Assam State Police Accountability Commission by its order dated 6/8/2050 passed by the so and so arising out of petitioner's application so and so, the court is of the consider with the FIR dated filed by so and so, filed by the informant OP on the basis of Hatigao PS case number under section 14 of the was registered, and petitioner arrest in his detention on the basis of the state PS case as well as charge sheet dated filed by the Hatigao PS and the order dated so and so passed by the trial court JMC framing a so and so and is illegal and bad in law. On the next paragraph, according to the FIR dated 26/9/2014 with regard to Hatigao police so and so under section 14, as well as charge sheet number submitted by the concerned in the said Hatigao PS number, as well as the order dated passed by the trial court in the court of JMFC arising out of the Hatigao framing charge under section 14 of the Foreigners Act against the petitioner are hereby set aside and quashed. My lord, this order, this judgment is from this honorable High Court, my lord, and it has been set aside and quashed. And then, my lord, there is another judgment.
This is not, the charge sheet has been set aside and quashed.
My lord,
You are asking for quashing the FIR.
quashing the FIR, my lord. Here the case, GR case number has been quashed and set aside, my lord. My lord, another case I would like to, where the writ petition has been filed, my lord. If I'm, my lord. Division based of this court has been given in paragraph number 5, my lord. Here, we are of the view that though the petitioner are presently detained in the transit camp Tezpur, they have already served out the sentence, and such there is no enumeraty of criminality to them except for the fact that they are being foreigners and they are liable to be deported, my lord. This is our case, my lord. However, at the same time, if they desire to seek refugee status from the UNHCR, we are of the view that right to seek for the same cannot be denied, my lord. This is our case, my lord. Paragraph number 5, my lord.
Okay, then let them go to the this one and these two judgments and place the submission.
Lordship, I think today I am praying for time, Lordship, so that I can take instruction. Because Lordship, if it is, yes, it is regarding the Foreigners Act of the he is submitting lordship. But also if that section, section has been added, then it will go because lordship, there are their statements are here. And as per their statement also, they are indulging trafficking also. For trafficking of person also, lordship, as per their statements, from their statements it reveals. So they are not the only person that they are moving around. They are after having that refugee card, also they are moving one place to another. That is not the simple thing, lordship. Only because of that moving around one place to another, they have been detained by the police. That is not the thing.
FI, it has not been written.
That is why, lordship, if it is not FIR, lordship, FIR initially, lordship, it was lost, lordship. Subsequently, if some statements, some new facts reveals, then police, what the IO used to do, they
Okay.
pray
All
for
right, all right. Let us give him some time. How much?
after vacation, lordship, immediately.
After vacation.
My lord, date may be fixed, my lord, because my lord,
After vacation.
this has been going on so and so,
Yes,
my
it's
lord.
all right.
After vacation, it's okay, my lord, but
Then you go to the judgments also.
18.
These two judgments also. He has submitted, you go to the judgments. Heard Learned Counsel, Mr.
AR Borua,
A.R. Burwa for the petitioner. One petitioner
for all the petitions.
for the petitioners and Learned Additional PP, Mr. P.S. Loker. To subsidies received, the Learned Additional PP has submitted that CD has to be updated as there is a note of the IO that some sections has to be added. Send back the CD, call for the up-to-date CD, list the matter on 24 July. Already?
May I please, Lordship? In this case, my lord, Mr. S. Chaudhary is appearing, my lord. Kindly add to my lord, 4-5 minutes will take, my lord.
No, no, no.
Then tomorrow, my lord. Kindly, my lord, tomorrow.
Tomorrow, yes, maybe.
Tomorrow, my lord.
Tomorrow.
Only 4-5 minutes will take, my lord.
Next week, no, no, no. At 2, we are very busy. Maybe after 2.
My lord, then after 2, my lord.
17, on 17.
My 117. Hello, bless. Hello, bless.
এজনৰ কথা কৈছো যেতিয়া এজনৰ কথা কৈছে দিব এটা ফটো লাভ নাই সাইন করতে একটু নব সাইন করি লিখ দিন কি এলিএমআই Okay. Okay.
Yeah. You have that one judgment
Yes, Lordship, I have
relating to that
simple delay, then,
safe security of the
yes.
safe
yes,
custody
yes,
of the sample.
Yes, Lord.
My lord, I want to submit a little bit, Lordship, on Ambale case, Lordship, Bharat Ambale's case, Lordship. I may counter.
What, yes?
Bharat Ambale on last occasion, on last day,
52A.
my land, 50, regarding 52A, Lord.
Oh, yes, Ambala case.
Ambale's case, Lord,
Okay.
which was referred, Lord.
What can submit? Who will start?
I will counter.
Let him complete.
No, my learned friend may, Lordship, submit.
Okay.
Yeah.
Paragraph I have written on top.
Paragraph.
Lordship. Let's get also, Lordship, there was explanation that there was a 2 days was holiday, so it was submitted on next date.
Okay.
Another judgment, Lordship. Paragraph 3 mana sila?
Paragraph 9 and 13 of this judgment. 2013 to crime SC, page 206. What his name is Mohinder versus State of Haryana. Paragraph 9. Regarding the delay in sending the sample contraband for examination of FSL, it was PW2 who carries the samples from police station to FSL at Madhuban but he was not asked any question in the cross examination, though the opportunity was given to the defense. Even otherwise, the FSL report exhibit P1 would show that the sample was received at the FSL intact with the seal, with delete with the specimen seals forwarded. Accordingly, the said objection is liable to be rejected. Your Lordship, same thing happened, Your Lordship. Here there is an explanation that there was a Sunday, so it was sent on Monday. And I have checked up the evidence of FSL expert. He said that he has received the samples intact. There was no tampering with the seal and others. Then paragraph 13 in this judgment is also important. As regards the reduction of sentence, it is not in dispute that the possession of 3.1 kgs of chromium involved commercial quantity and if that, so in terms of subsection B of section 18, imprisonment less than 10 years. Admittedly, there is no enabling provision to the court for reducing the sentence by giving special or adequate reasons, statutory particulars in section 18. Accordingly, we reject the request of the learned counsel for that. Minimum sentence is to be maintained. Lordship, with regard to independent witness, I have given two judgments. Probably delay in sample, Lordship, I think the two judgments are sufficient. In Odisha judgment, Lordship, same is covered by our cases.
But you see here, this appeal is by the accused, I think.
Which
Oh,
one?
no, state, oh,
But the state, there was
Ah,
the
but
acquittal,
it was,
then it was
against acquittal, no?
Lordship. This is with regard to independent witness. Last week, then I given the citation, Lordship, this is a judgment.
Okay. There's that Mukesh Singh's judgment also relating to independent witnesses.
Independent witness, Lordship, if
That
the,
Mukesh Singh's famous judgment.
yes, Lordship,
And that IO is the complainant and the investigating officer.
and Lordship, moreover,
Everything was covered.
learned trial court has also discussed with regard to independent witness this judgment. And
Trial
Lordship,
court has also discussed.
yes, Lordship. Although no judgment was referred, Lordship, regarding the intake of the deposit of sample in the godown, Lordship may please to see PW3.
Oh, that you have pointed out. I have noted
Exhibit 10 and 11 at the godown receipt.
exhibit 10 and
Yes,
11.
10 and 11. Now, Lordship, the point remains with regard to 52E. This
Exhibit 10 and 11 are the Malkhana
yes, Malkana receipt, godown receipt.
go down receipt.
Now, Lordship, the another point remains, it is the section 52E. It admittedly, Lordship, sample was.
Ambale judgment.
No, Lordship, I am coming to that. In that case, Lordship, here admitted samples were taken on the spot. There was no photograph, no certificate from the learned magistrate is there. Lordship, Ambale, paragraph 9 and 10, paragraph 39. That's it. Ambale judgment liaison.
Para 9 and
So last paragraph where conclusion was given.
last paragraph is paragraph 50.
That paragraph 9 and 10, Lordship.
Ambale judgment.
Ambala's judgment that we summarize our final conclusion as under 50, paragraph 50, subparagraph, Lordship. That final conclusion in the last part of the judgment. 9 and 10.
9 and 10, okay.
Roman 9 and 10.
And Supreme Court says that if there is no compliance, that will not come to
Yes, yes.
acquittal also. Because the lordship has to see that if the purpose of taking sample is explained in the judgment, so in paragraph 2 and onward. Lordship, all these judgments where Supreme Court says that if section 52 is not complied, then the FSL report, nothing will be a paper. But that has been, all these judgment has been discussed in this, in these judgments.
Okay. Actually, this many appellants, they got acquitted because of this section 52A. So finally, this was summarized. Finally, this was taken into consideration and dealt with. Section 52A.
Yes,
Earlier, many acquittals.
Yes,
were-
earlier it was, many acquittal was there, but after lordship precedent this judgment, the law has been changed. And that's been explained. Again, I'm placing lordship paragraph 50. We summarize. We have to read all these points lordship together. I'm reading and again lordship for benefit.
Okay, okay.
We summarize our final conclusions under. Although section 52A is primarily for the disposal and destruction of the seized contraband in safe manner, yet it extends beyond the immediate context of drug disposal, as it serves a broader purpose of also introducing procedural safeguard in the treatment of narcotic substance after seizure, in as much as this provides that the preparation of inventories, taking the photographs of the seized substance and proving samples therefrom in the presence with the certification of the magistrate. Mere drawing of samples in presence of the gazetted officer would not constitute sufficient compliance of mandates under section 52A, subsection 2 of the NDPS Act. And 2, although there are no mandate, the drawing of sample from the seized substance must take place at the time of seizure, as held in Mohanlal. Yet we are of the opinion that the process of inventorying photographs and drawing of samples of the seized substance shall as far as possible take place in presence of the accused, though the same may not be done at the very spot of the seizure. Then 3, any inventory, photographs or samples seized substance prepared in substantial compliance of the procedure prescribed under section 52A of NDPS Act and the rules standing orders thereunder would have to be mandatorily treated as primary evidence as per section 52A, subsection 4 of section NDPS Act, irrespective of whether the substance is originally actually produced before the court or not. Then 4, the procedure prescribed by the standing order rules in the term of section 52A NDPS Act is only intended to guide the officer and to see that a fair procedure is adopted by the officer in charge of the investigation, and as such is required the substantial compliance of the procedure laid therein. Then 5, mere non-compliance of procedure under section 52A or standard orders rules thereunder will not be a fatal to the trial unless there are discrepancies in physical evidence rendering the prosecution's case doubtful, which may not have been done, has been there, and had such compliance been done. Court should take a holistic and cumulative view of discrepancies that may exist in the evidence adduced by the prosecution and appreciated the same more carefully, keeping in mind the procedural lapses. 6, if the other materials on record adduced by the prosecution, oral or documentary, inspires confidence and satisfied to the court as regard the recovery as well as the conscious position of the contraband from the actual position, then even in such cases, the court can without hesitation proceed to hold the accused guilty, notwithstanding any procedural defect in section 52A of the NDPS Act. And 6, non-compliance or delayed compliance of the said procedure, provision or rules thereunder may lead to court to draw an adverse inference against the prosecution. However, no hard and fast rule can be laid down as to when such inference may be drawn, and it would be all depends on the peculiar facts and circumstances of each case. And 7, here there has been lapse on the part of the police in either following the procedure laid down under section 52A of the NDPS Act or the prosecution in proving the same, it would be not be appropriate for the court to resort to such statutory presumption of commission of offence from possession of illicit materials under section 54 of the NDPS Act, unless the court is otherwise satisfied as regard the seizure and recovery of such materials from accused persons from other materials on record. The initial burden will be lie on the accused to first lay the foundation of facts to show that there are non-compliance of section 52A, either by letting evidence of its own or by relying on the evidence of the prosecution, and the standard required would be only be preponderance of probabilities. And 10, what the fundamental facts that indicate non-compliance of section 52A NDPS Act, the honors would thereafter be on the prosecution to prove the cogent evidence that either 1, there was substantial compliance with the mandate of section 52 of NDPS Act. 2, satisfy the court that such non-compliance does not affect in case against the accused on the standard of proof requires will be beyond reasonable doubt. But these are the guidelines framed by the Honorable Supreme Court after discussing all the judgments of Mangilan and Yusuf that has been clearly held that if there is no compliance, then the accused is entitled to take it. But from this judgment, what if the law has been notified and the procedure has been laid down by the Honorable Supreme Court? Here, Lordship, I have also gone through the evidences of different witnesses. I didn't find any question was put with regard to section non-compliance section 52, the prosecution witness. And regarding sample was intact, it was drawn in presence of the accused and 2 independent witnesses at the time of seizure also. So all the procedure has been followed as indicated by the Honorable Supreme Court. So in my humble submission, Lordship, the petitioner, the appellant has failed to make out a case for acquittal. In this case, Lordship, the conviction is required to be upheld. I have submitted one judgment, Lordship, which indicate that in any case, the sentence cannot be reduced in any manner. Then the conscious position has been proved. And in my humble submission, Lordship, conscious position is proved by the witnesses. In view of the same, Lordship, in my humble submission, the appeal is liable to be dismissed.
He has already served his sentence.
Lordship?
He has already served his sentence. He's
No,
only
if
asked to
he is
go
already served, then
after paying 1 lakh rupees.
Lordship, but Lordship, in case of NDPS, the sentence cannot be reduced.
No, nobody is reducing his sentence.
No, if he is Lordship served, then there is no question of.
He is asked to pay 1 lakh and go. He doesn't want to pay 1 lakh.
Then Lordship is to consider on merit whether
Yes.
prosecution is approved their case or not.
Yes.
And in 2015 judgment, Lordship, the Supreme Court has clearly stated this minimum sentence cannot be reduced.
No, his
No,
sentence
any
is not
circumstance.
reduced. He's already asked the jail authority to pay the amount and go.
No, Lordship, here I have calculated till 28th of January, he has completed 8 years.
Oh.
Definitely, he will get some
Holidays.
holidays.
Mm.
That is to be calculated.
So when you'll get the holidays, I think he has served his sentence, I'm sure.
Then that I'm not calculated.
I'm sure he has served it. Otherwise, why the jail authority will ask him to pay the fine amount and go?
But then
They asked him, Lordship, to deposit the amount within this month. so
Within
that he
this
can
month
be-
and go.
That I have not aware. I cannot.
I think he has served his
No,
sentence
if he has,
completely.
he has completed sentence, Lordship, then Lordship,
Only that amount may be.
No, he doesn't want to pay the amount.
then Lordship,
That is why he's asking for acquittal.
Yes.
no, Lordship, then Lordship has to consider on merit also.
Yeah, of course. I'll consider on merit.
Then I have nothing to say. I have submitted that.
I'll consider on merit, yes.
that
I
because-
think he has a case, I think. I think because this Ambala's judgment, I think you cannot escape with the 52A route.
Lordship, because Lordship, only the fact is that 9 and 10 Lordship. In the 9 Lordship, initial burden upon the accused.
Yes.
But that there has to prove that 52 is A was not complied by relying upon the evidence of the prosecution. So I am relying upon the evidence of the prosecution. There is a seizing officer's evidence, Lordship, PW3, where he clearly stated that, Lordship, in the cross.
Photographs are not taken.
Yes, Lordship, that on 28/1, before sealing the seized articles, I did not prepare the inventory in presence of magistrate and certified its correctness by a magistrate. So here he clearly admitted, Lordship.
This is my.
So I have put the question.
We have not taken the sample before that. There is no certificate from the magistrate. And Ambala has said that any non-compliance will not.
Maybe, Lordship,
entitled
but
to active
initial burden upon me, so I have shifted the burden, Lordship, upon them. So they may, then in 10, Lordship, that was clearly
There's no
indicated.
certificate by CJM, it is true.
Yes.
It is.
He has admitted.
It is
no
admitted.
certificate by CJM. So now you see, not only 9 and 10, even Ambale's judgment, this not paragraph 9 and 10.
Entire Lordship, this guideline is to be read.
Paragraph 5, no? Ambale's judgment,
That paragraph 50, Lordship, main paragraph 50,
main 5 of 50, you just see.
Roman
5 of
5.
50.
Mere non-compliance of the procedure.
Yes.
Yes, Lordship.
Oh.
Will not fatal the trial unless there are discrepancies in the physical evidence, rendering prosecution's case doubtful.
See, there is no discrepancy in the physical.
Yes, Lordship, but
evidence.
Lordship, the fact is that without Lordship examination of the independent witnesses, the seizure.
No, independent
should-
witness, there's nothing about independent witness.
Yes, Lord, and
There are so many judgments. There's
Yes.
there's no judgment that if independent witnesses are not examined. Fatal to the case. There are no judgments in NDPS Act.
Lordship,
But there are many judgments in the NDPS Act, including Mukesh Singh,
Yes.
that if independent witnesses are not examined, the case, it will not be fatal for the prosecution case.
yes, Lordship. Moreover, Lordship, the chain of custody, safe custody of that on
No, that
29
has been
Sunday,
proved. That has
they have
been-
explained, but no evidence was produced that where it was kept, Lordship. It must be kept somewhere, Lordship.
It is there, in the
Paragraph
cross-examination of
eh, eh,
PW3.
In the cross-examination, he said that it was Lordship produced before the CJM, and on 29 it was not
Cross-examination of
sent.
PW3, it is there.
Exhibit 10 and 11 is the proof of.
No, 10 is Lordship only 28/1 go down receipt. On 28/1 it was kept in the go down. 29/1 it was exited.
This is a very unfortunate case. It has come after this judgment, Ambale's judgment. Otherwise, there is no escape
Yes, Lordship.
Yes, Lordship.
in this case.
There are certain Lordship, your Lordship may consider the that aspect also, Lordship.
You'll have to pay 1 lakh. I'm sorry. You don't, because all the acquittals I have given last 1
Yes,
year,
Lordship.
it was only on 52A.
In many cases, Lordship.
But this is not, Lordship, it is in the Ambala's judgment, Lordship, that there are no clear-cut rules that should not be followed. If in every case, Lordship, if that was not followed, then the case will not go. That was not their Lordship. But the onus is upon me.
This is the first time I'm going to uphold a trial court judgment. I'm sorry. First time I'm going to uphold. First time in 4 years.
Yes, Lordship.
Huh? Yes, he's very happy.
No,
First
Lordship.
time in 4
No,
years.
regarding happy and sad is Lordship because the law has been changed now.
Oh.
And the same matter is considered by the division bench, Lordship. On 20th case has been fixed. Same point has been
Which one?
in division bench regarding appeal against them. That case 20 years has been.
Oh, 20 years.
Yes.
Division bench.
They have taken this point, Lordship. The court has said that after Ambala's judgment, our hands are tied. And that division bench also given acquittal in another case.
I'll just check the judgments one by one.
Lordship.
Lordship, I have submitted some judgments, Lordship. Your Lordship, and I have all those judgments.
Yes. I'll go through it. I'll quote the judgments.
Yes.
Quote the judgment. Not all, but I'll quote the judgment. You can keep fighting for 1 lakh up to Supreme Court.
My lord, that is the
another
Lordship,
thing.
peculiar circumstances, Lordship.
Lordship, another thing.
Otherwise,
here,
you will
if
again,
he-
Lordship,
if
suffer.
completely 10 years. Then Lordship, in default, he has to undergo another 1 year. Probably within 6 months, he will be free.
Another 1 year in default.
Yes,
But default sentence cannot be set up.
yes, Lordship, cannot be set up.
Cannot be set up. But somewhere I have seen, not somewhere, in all the judgments I have seen, setting of default sentence actually cannot be set up.
Cannot be set. But,
Cannot be set up.
in case of NDPS also, Lordship, the
In any way, default sentence cannot be set up. Even 1 month default also cannot be set up. I'll have to finish this judgment today. Because this person has to pay the money and go.
Yes.
I'm talking to the people who are sitting and waiting. This person has to pay the money and go. I'll have to finish this judgment. Because otherwise this person will suffer a lot.
But that, as per my instruction, he could not able, because since last 8 years, he is behind the curve.
Yes, yes.
So Lordship, now they are not in a position, Lordship, to pay.
To pay.
Yes, Lordship. So that may be considered, because Lordship, otherwise we will again suffer another one
And fine, no?
fine.
And fine.
And in default.
Can the fine be reduced from 1 lakh? No, no. Fine is 1 lakh.
Yes, I mean, this is a minimum. Sentence.
Minimum.
Minimum sentence. And I've produced judgment.
Where's the NDPS section? Let me see.
Probably he is convicted under section 18.
18 to B, I think. Let's
What?
see if the fine can be reduced. Otherwise, imprisonment cannot be reduced. Twenty B to C.
To B, Lordship B.
20 B to
It may
C.
be extended to 20 years,
Hmm.
but which may be extended to 20 years and shall also be liable to pay fine, which shall not be less than 1 lakh rupees, which may be
See,
extended to.
Cannot be
2
reduced. I'm
lakhs.
sorry. Otherwise, I would have reduced the fine.
And Supreme Court judgment is very clear.
20 B to C, 1 lakh.
1 lakh minimum only.
Every code imposes the minimum only.
Yes, Lordship, normally minimum. In
Not,
exceptional cases,
not more than minimum, never.
but in some cases, Lordship is has been ordered section 32B, court has to give explanation if sentence more than minimum sentence is provided.
Okay, should give explanation. একটু বন্ধ করে দিবা judgment লিখে।
Number 32, on the last occasion when this bail petition had come up before the honorable court, then the honorable judge had held that the merits of the case have to be looked into, your lordship. So it was fixed for final hearing today.
After first day after vacation, 15 July. 15 July, first day after vacation. Hearing day, first day after vacation at 2. This is matter on 15 July at 2.
I'm blessed.
Your Lordship,
Obliged.
first item number 33, read name, please.
Is this matter after vacation?
After.
Bail, urgent bail.
Urgent, my lord, he is,
Are you sure you'll get bail?
technicalities are there, man.
Okay, then we will bring it back to the orders then. Or we'll begin,
My lord will consider the entire evidence, my lord.
Then after vacation.
then after vacation, not on 15, but
Then my lord,
17
my lord will pick
at 2.
17.
17. Too late, my lord. Then only the I may be considered.
I before vacation. Okay. List this matter in the orders column as the learned counsel has pressed for his IA. Huh? In the orders column, it will go back to the orders column on 24th June.
My lord.
See, if there are a lot of technical
My
issues,
lord.
then
We will have to
we'll
go through it.
back to
My
April.
lord.
But NDPS is all about technicalities only.
NDPS.
NDPS.
Just now I have upheld the trial court's decision.
Mm.
NDPS, you are behind bars for how many days?
3 years.
3 years.
3 years.
And
On,
convicted for how many years?
10 years.
10 years.
Yes. Only 18 bottles of cough syrup.
Only cough syrup.
Yes.
Total is my lord, sufficient for commercial.
How many bottles are sufficient for
10.
commercial?
10
10.
years.
They say 10.
What kind of, don't say 52A. Now there is a
No,
judgment.
no, not relying on 53. 53 is
Why don't you have some patients till
Final hearing.
final hearing?
Even if for the IA, we will have to go through the
That's why-
record,
that's
on
why-
the record.
That's why, my lord, the
How
matter
many
was.
years you were behind bars? You were on bail in the earlier
No, no,
case.
From the date of arrest,
From the date of arrest?
Yes.
So total, how many years you are behind bars?
around 3 years.
Total?
Yes. And he's young also, my lord.
This case was decided instantly,
Yes. Custodial trial was held.
very fast,
Yes.
3 years. All right then.
Well.